This week brings several important developments in tax and corporate laws, with courts and tribunals clarifying long-standing issues around capital gains, procedural compliance, and exemptions. We begin with a notable ruling from the Bangalore Tribunal in the case of Vijay Lakshmichand Israni versus Income Tax Officer. In this case, the assessee had sold a residential property and claimed that various fixtures and installations constituted cost of improvement. The tribunal observed that only those items that were permanently attached to the walls or embedded into the structure could be treated as part of the property itself. Such expenses legitimately enhanced the cost of improvement. However, movable items such as air conditioners were regarded as personal effects and did not qualify for deduction. As a result, a proportionate disallowance was upheld. The tribunal also dealt with the assessee's claim for deductions on air tickets, meals, boarding, and local travel incurred during a visit to India for the purpose of selling the house. Since the assessee could not prove that the sole and exclusive reason for the visit was the sale transaction, these expenses were not allowed as costs incurred wholly and exclusively in connection with the transfer. Moving to charitable trust matters, the Hyderabad Tribunal delivered an important ruling in the case of Sri Ajaya Sankara Trust versus CIT exemption. The trust's application for regular approval under Section 80G5 had been rejected purely on the ground that it was filed beyond the prescribed time limit. The tribunal noted that the statute did not provide a mechanism for condonation of delay, but strictly enforcing this omission would result in undue hardship for genuine charitable institutions. To prevent injustice, the tribunal set aside the rejection and directed the trust to approach the CBDT for condonation of delay. The ruling emphasizes that procedural gaps should not defeat substantive charitable objectives when the applicant is bona fide. The Madras High Court also issued a significant decision in Gauthaman versus Income Tax Officer concerning reassessment proceedings initiated under Section 148A. In this matter, the assessee had passed away before the issuance of the notice, and neither the petitioner nor the other legal heirs informed the Income Tax Department of the death. The court held that in such circumstances, the petitioner could not later claim that the assessment proceedings were invalid simply because the notice was issued to a deceased individual or that the proceedings were time-barred under Section 153(2). The judgment reinforces the responsibility of legal representatives to notify the department promptly in the event of the assessee's death. Another taxpayer-friendly ruling came from the Jaipur Tribunal in Dalit Singh Haldia versus Income Tax Officer. Here, the assessee had invested the full sale consideration of a residential property into a new house purchased jointly in his own name and in the name of his son, who was suffering from schizophrenia. The son's name was included to avoid inconvenience in future, and the department did not dispute that the entire investment was made solely by the assessee. The tribunal held that the assessee was entitled to the full exemption under Section 54F, as beneficial ownership and full financial contribution rested entirely with him. From the Delhi High Court, an important judgment was delivered in Principal Commissioner of Income Tax versus KRBL Infrastructure Limited. The issue involved an unsecured loan received from a corporate lender. The assessee had produced confirmations from the lender's director, and bank records clearly established availability of funds and genuineness of the transaction. The court ruled that the identity, creditworthiness, and genuineness of the loan were satisfactorily proven, and that the department could not require the assessee to prove the source of the source for the relevant assessment year. As a result, the addition made under Section 68 was held to be unjustified. Turning now to developments under GST, the Supreme Court clarified the scope of exemption available for residential dwellings under Entry 13 of Notification Number 9 of 2017. In this case, a co-owned residential property was leased to a company, which in turn sublet the rooms as hostels to students and working professionals for long-term stays. The court held that the exemption could not be denied merely because the lessee was a corporate entity. What matters is the actual use of the premises by the occupants. Since the end users were residing in the property as their dwelling, the exemption continued to apply, The ruling highlights that the exemption is activity-based rather than person-specific. Finally, the Calcutta High Court reinforced the principles of natural justice in GST adjudication. The court held that when a taxpayer specifically requests a personal hearing, the authorities cannot dispose of a rectification application without providing that opportunity. Any such dismissal would be procedurally improper and liable to be set aside.